I am Kuljit Bhogal. I am a barrister here at Cornerstone Barristers, and in 2023 was appointed a King's Counsel or a KC. I also sit as a recorder in the criminal courts, hearing Crown Court trials with juries. And today, as I say, I'm going to be focusing on Martyn's Law. It's legislation that was passed earlier this year. And in researching the preparation for this webinar, I was rather surprised to learn that since the start of 2017, the security agencies and law enforcement have disrupted a total of 39 late-stage terrorist plots. And in addition, there have been 15 domestic terror attacks, including the 2017 attack at the Manchester Arena during the concert of Ariana Grande. So there are a considerable number of these attacks that are being disrupted before we get to hear about them. And as we know, unfortunately, a number of them do make the headlines because they are successful or successful to some degree. And so 2017, there were 22 people that lost their lives at the terror attack at Manchester Arena. And there was a public inquiry as a result of that. And in the report from the inquiry chair, one of the recommendations was to ensure that there was legislation introduced to improve the safety and security of public venues. Sadly, that's not the first time observations of that sort have been made. There was a prevention of further deaths report, which resulted from the London Bridge and Borough Market inquests, which also recommended the introduction of legislation to clearly set out the duties of owners and public authorities regarding protective security. And back in 2017, there was an Intelligence and Security Committee recommendation to do the same as part of 5 terror attacks that were considered back in 2017. And so Martyn's Law is the government's response to the various occasions on which there have been recommendations made about the need to have some form of active responsibility to take measures to protect people in the event of a terror attack. And that's what we're going to be focusing on today. In terms of the actual legislation, as I say, it received Royal Assent on the 3rd of April of 2025, and it delivers on the government's manifesto to do more in relation to the security of premises when there are public members of the public gathered. And it's very much as a result of the campaigning of one of those that died and the family of that individual that has meant that we have got legislation and some active duties that are going to be coming into force. And although the legislation came into force on the 3rd of April, what the government has said is that there will be an implementation period of at least 24 months before the requirements of the legislation are going to start biting. And that period of time is designed to ensure that people that are responsible for premises and events that are in scope have time to plan and prepare appropriately. Now, we're already 3 months into that time frame, and the remaining time is going to pass, no doubt, very quickly. And I thought it was timely to ensure that there was some information disseminated in relation to the requirements of the Act, so that those of you that are responsible for premises or events are able to understand the shape of the obligations that are going to be coming down the line. So in terms of where the Act bites, it bites on premises which are used for Schedule 1 purposes. So what's Schedule 1? On this slide, I've included a number of Schedule 1 uses. They're not all of them, and some of them have been abbreviated to get them on the slide, but you can see there that the types of premises that are in scope is very broad and varied. So we have shops, we have hospitals and healthcare facilities, we have bus coach stations, so public transport hubs, aerodromes, sports grounds and the like. All of these are Schedule 1 uses. And if you are involved in an event or are responsible for premises, and we'll look at what responsible persons means in the context of this Act, But if you're connected to premises or events where there is a Schedule 1 use, then you are potentially in scope as far as the legislation is concerned. There are some uses which are excluded, and I've put those on this slide. And in addition, there are some uses which are described as standard duty uses, and we'll come on to look at what standard duty and enhanced duty means. But in a nutshell, in relation to those standard uses that are always standard duty uses, they are things like childcare and places of worship. And there may be other uses which are prescribed in due course, but childcare and places of worship will always be standard duty, and we'll come on in a moment to look at what that means as far as the those of you that are involved in advising premises owners or people that are involved in hosting events. So in relation to the legislation in a nutshell, the purpose of the legislation is to ensure that if you're in scope, so if you're responsible for a qualifying premises or a qualifying event, you are going to be obliged to take certain steps to reduce the risk of physical harm to individuals arising from acts of terrorism. And for larger qualifying premises and all qualifying events, you're going to have to take steps to reduce the vulnerability of those events and those premises to acts of terrorism. That's the legislation in a nutshell. And in relation to licensed premises, what the Act does is amend the Licensing Act of 2003 and the Licensing Scotland Act of 2005 to require the provision of two plans to the local licensing authority. One is a detailed plan for the local authority's use, which includes details such as layouts, routes of escape, what various rooms are used for and the like. And then a less detailed plan that's going to be made available for public inspection. And the reason there are two plans is obviously the detailed plan that's provided for the local licensing authority may well contain details that are helpful to someone who's potentially engaged in terrorist activity. And of course, one doesn't want to make those details public. And so it's a less detailed plan that's made available for public inspection as part of the application for a new premises license. And then a detailed plan that's for the local authority's use. And the idea is that it's available in the event of an emergency, accessible to those should they have the need to refer to it. In relation to whether or not you're in scope, now the question here is whether or not you are a qualifying premises or a qualifying event. And with qualifying premises, as I've put there on the slide, there are two types. And if you're concerned with premises where there are up to 199 people, so less than 200 people, you're not in scope at all. However, if you have premises in which there may be present at any given time 200 people, then you are going to be described as a standard duty premises. And that bites for those premises that have 200 people or more, up to 799. As soon as you hit the 800 number, you are an enhanced duty premises, and there are some enhanced duties that apply as a result of having that greater number. In terms of how you calculate those numbers, you are required to consider whether or not there are the relevant number of people, including members of staff. So it's not just about the people that might be attending the premises or the event to participate in a meeting or a concert or whatever it might be. But in counting that number, you have to take account of the staff that will be present. So that might mean security staff, it might mean reception staff, it might mean cleaning staff, but all of those get included in calculating the number of people that count towards the 200. And the same applies with when you're looking at calculating the 800. you have to take into account all of those people that might reasonably be expected to be present. It's also worth noting that it doesn't mean 200 people all of the time. So you can have premises in scope where there might be certain times of the year where there are, say, 200 people present. So I don't know, one might think of in the rush leading up to Christmas, certain shops might be busier than they might otherwise be. If that's the case, you become a standard duty premises or enhanced duty premises, depending on the numbers, even if for the majority of the time you are below the threshold number. So it is worth looking at and considering carefully, not just what happens in relation to particular events or particular uses, but even if they are occasional uses where you hit the number, you then fall in scope for the purposes of this legislation. The exceptions are those premises which are going to always be standard duty premises, even if there are sometimes 800 or more people. And I've already mentioned those. So if you're a childcare premises or if you're a place of worship, even if you might have 800 people present at any given time, the legislation says that you are treated as a standard duty premises for the purposes of the requirements in this legislation. So subject to those two exceptions for those two types of use, for everybody else, for standard duty and enhanced duty, those are the numbers that one needs to have regard to. Just staying with qualified premises for a moment, you might have a situation where you have a qualified premises within a qualified premises. So, for example, you might have a shopping centre, which is a qualified premises, but then also a retail unit within the shopping centre could be a qualifying premises. The legislation also covers not just a building, but groups of buildings. And a good example there is a university campus, which might be made up of a collection of buildings. And when one comes to calculating the numbers, you look at that collection of buildings and whether or not they fall in scope by reason of the numbers that are specified within the legislation. So those are the two types of qualifying premises. You then have qualifying events. So this is the other way in which you can be in scope. And this is where you're not already an enhanced duty premises, but you're going to have 800 or more people present, or you reasonably expect 800 or more individuals to be present. And there are measures in place to check access. And what the Act says there is that that means that either people have paid to have access or they have tickets or passes which allow them to have access, or they're members of a club or an association and the event's not an excluded event by virtue of Part 2 of Schedule 2. But it's important to note that the issue here is not about whether or not you pay to have access. It's about whether there are measures in place to check access or control access. And so it's not whether or not you're in scope is not determined by whether or not you've paid for a ticket. You might have a free ticket. It's the fact that a ticket is being checked that has the potential to bring you in scope. And those checks might be checks done by virtue of a ticket or a turnstile or AI, or you have volunteers standing there checking that people have the relevant documents or the relevant email on their phone. It's about that control of access and those checks of access. And if that exists and there's 800 or more people reasonably expected to be there, you are a qualifying event for the purposes of this legislation. And so you can see that the broad scope of this legislation, the key numbers are 200 and 800. And either that means you're going to be standard duty or potentially enhanced duty, or you're going to be in the scope of a qualifying event. Before I leave these two concepts, a couple of the questions that have been sent in advance of this webinar related to markets and whether or not local markets in local authority areas might be caught by the legislation. And I haven't been given enough detail about those specific examples, but generally speaking, a market or a car boot sale or something of that sort wouldn't normally have measures to control access. So there might be a market taking place, I don't know, on a car park on a Sunday, or you have a weekly farmers market or something of that sort, as long as you don't end up being in scope because of there being measures to check access, uh, markets and similar events will not be in scope because there isn't the checking of access. However, if it is the type of event where access is checked or there's an entry ticket, not necessarily on payment, but just some control or check on access, then you are looking at being in scope of the requirements of the legislation. In terms of calculating the numbers, just looking at qualifying events before we move on, one of the examples given in the explanatory notes, which may be relevant to some of you, and particularly some of you that represent local authorities, is where you have a public park and there is a music event taking place in the park. If the music event is reasonably expected to have 700 people present, it's not going to be a qualifying event just because the whole park has more than 800 people present. So it's about the event itself, not necessarily about the wider area. But I suspect there are going to be some discussions around whether or not this puts an event in scope or out of scope, particularly when you're at the borderline of those numbers, whether it's at the 200 or 800 mark. But that example is specifically one that's given in the explanatory notes as being out of scope because you haven't hit the 800 number in relation to the event itself, and you don't take into account the broader numbers in the park itself. So those are qualifying events and qualifying premises. There are a number of key concepts that are covered in the legislation, and I'm going to go through some of these over the course of the next few slides. In relation to what you actually have to do, Section 5 of the legislation requires you to have to ensure that there are appropriate public protection procedures in place where you have a qualifying premises or a qualifying event. So what are public protection procedures? Well, the legislation makes clear that you need to have measures in place to deal with evacuation, to deal with moving people to a place on the premises where there's less risk of physical harm being caused, to prevent people from entering or leaving, and to ensure that information is provided to individuals. And at the end of these slides, I've got some further resources, and one of them is a link to a video that's been prepared about what to do if you're. The example is a cafe within a shopping centre, and there is somebody walking around with a knife. And what do you do if you're responsible for the cafe to ensure that the people on your premises are kept safe or as safe as can be and protected from that threat or that risk? And it's a 5-minute video, well worth a watch. Just demonstrates some of the simple measures that can be taken in relation to compliance with the requirements. And certainly as far as standard duty premises are concerned, the expectation is that those are meant to be simple, straightforward to comply with requirements that shouldn't really require any specialist input, but just some thought given to what you would do in certain given circumstances. So well worth a watch, and I'll flag the link to that video in the later slides. So that's what you're required to do, have public protection procedures in place. There are additional requirements in relation to enhanced duty premises, and they relate to assessing and reviewing measures to reduce the vulnerability of those enhanced duty premises or the qualifying event to the risk of physical harm to individuals in the event of a terrorist attack, and ensure that those measures, the measures that you've assessed and reviewed as being needed, are in place so far as reasonably practicable. And public protection measures for the purposes of an enhanced duty premises or qualifying events are described as in section 6.3 as the monitoring of the premises or the event, monitoring of the movement of individuals into and out of and within the premises or the event, to look at the physical safety and security of the event, but also the security of information in relation to the event. And as I say, those are the measures for enhanced duty premises or qualifying premises events. For standard duty premises, the requirements are intended to be simple and focus on having procedures in place and awareness, staff awareness and the like as to what is expected in the event that there is an issue of this sort. There are notification requirements in terms of what else you have to do, and those who are responsible for standard duty premises are required to notify the security, the SIA, that they are the responsible person for the purposes of those premises. And for enhanced duty premises, you need to have your public protection measures in place, but then also document those procedures and measures. And those are subject to certain enforcement and investigation requirements that I'll come on to. In relation to who's responsible, the Act defines responsible persons in Section 4. And so you're responsible for, as for a qualifying premises, if you have control of the premises in connection with the Schedule 1 use, which are the bubbles that were on the earlier slides. And you're the responsible person for a qualifying event if you'll have control of the premises at which the event is held in connection with your use of the event. And where there's more than one person responsible for the qualifying premises or the qualifying event, references in the Act are to each responsible person, so there can be more than one. And where you've got a situation where you don't have an individual that's responsible, the requirements are to designate someone that is responsible, and that feeds into the criminal offences that are created by the Act, which we'll come on to shortly. And so you have to designate a person that's of a sufficient seniority in order to be the responsible person. And so to give you some examples of how this might work, in the context of a theatre and the organisation that operates a theatre, it would be that organisation that is the responsible person. In the context of a shopping centre, it's likely to be the person or the organisation that holds the lease for the shopping centre. However, where you've got a situation where you hold the lease, say, for the shopping centre, but you appoint a contractor to work at the premises to provide security, it's highly unlikely that the security company will be the responsible person. The responsible person will remain the company that holds the lease for the shopping centre. This is an area where I think there's potentially some room for discussion, because the explanatory notes give an example of a situation where a company holds a concert in a park. And the suggestion is that they will be the responsible person because they control that area in the park. And they also give an example of a stately home that puts on a concert within its grounds. And there they say it's the stately home that remains the responsible person because they maintain control of the site, even if security and the like is contracted out. It seems to me, however, that there is scope for some discussion here, because there's not much difference between the concert in the park and the stately home with the concert, in that the event itself, the performers and the like that are going to be participating, the chances are that's controlled by the company, whether it's happening in a park or happening in the grounds of a stately home. So it's not entirely clear why, if it's in a park, the company's responsible, but if it's in a stately home, it's not the company putting on the concert, but it's the stately home that remains responsible. I think the argument is that the stately home is responsible for its own site and its grounds, but it seems to me that this is an argument where there's potential mileage for there to be disagreement between who is actually the responsible person. So it's a case of watch this space and see whether there's any further clarity provided in the guidance. So once you've got the responsible person, you know what it is that you have to do in terms of procedures and measures. The next thing is, how do you demonstrate what you've done? And this is one of my bugbears in relation to various areas that I practice in, and that's about record keeping and the need to have good record keeping. So Section 7 of the Act specifically requires there to be, in relation to enhanced duty premises and qualifying events, a statement of procedures, an assessment of how those procedures reduce the risks that have been identified in Section 5.2, a statement of the measures that have been put in place or are proposed, an assessment of the measures to reduce the vulnerability and risk mentioned in Section 6.2, and then any other information required by regulations. And so those measures, that is a requirement for there to be a written process and a written assessments as set out on that slide. And those records have to be kept and need to be kept in good order and reviewed from time to time to ensure that they're fit for purpose. And that's how you demonstrate that you have complied with the obligations imposed by the Act. And should you be subject to an investigation, that's going to be one of the ways in which you demonstrate that you've complied with the duties that have been imposed. So having created the duties, having created the responsible person, and having created a requirement to document some of the way in which the obligations are being met, there is then a mechanism within the Act to allow for determinations by the tribunal. And the sorts of things that the tribunal can decide are specified within the Act, and they're set out on this slide. I won't read them all out, but one of them is D, whether an event is a qualifying event. So that concert in a park or concert in a stately home is potentially something that can be determined before the event takes place if there is a disagreement or uncertainty, so that the tribunal can make a decision and there can be certainty going forwards. Equally, the tribunal is given power to decide whether or not premises fall within enhanced duty premises or whether the use is a relevant Schedule 1 use. And I can see where you've got more than one use. What the legislation says is it's the principal or main use that's the use that should be used. But where there is a dispute, that the Act provides for a resolution mechanism by being able to apply to the tribunal. So that's how determinations to the tribunal work. And then we have some information about the teeth of this legislation and the investigation and enforcement powers that are given to the Security Industries Authority. And what they have been given or will be given when the Act goes bites is the ability to investigate and issue compliance notices, restriction notices, and also penalty notices. And what they are required to do, in addition to the enforcement and investigation, is issue some guidance about how it proposes to exercise its functions so that there is some transparency around which premises will be treated as standard or enhanced, how those decisions are going to be made, decisions around the expectation that the Security Industries Authority has in relation to documentation, and to prepare that guidance. It's not been issued yet, but to issue that guidance so that those of you that are advising premises and people holding events can have some expectation and understanding of what the SIA is going to be looking for when it comes to investigating and potentially where you might be at risk of being the subject of enforcement action in the event that the SIA decides to investigate. So there's the power to issue compliance notices and restriction notices. And I've set out there some information about them. What I wanted to add is two things. First of all, before issuing the notices, the SIA is required to notify the responsible person of their intention to issue a notice and also give an opportunity for that person to make representations. So it shouldn't come out of the blue. It ought to be a dialogue before you end up being on the receiving end of enforcement. What's also interesting about the penalty notices is the amount of fines that are available to the SIA, and they are considerable. And I'm going to come on to deal with some of those. So, in relation to the maximum amount of penalties that can be imposed by the SIA, if it's a failure to comply with the requirement to attend an interview, the maximum fine is £5,000. If it's about a contravention in respect of a standard duty premises, so these are the ones where the requirements are meant to be straightforward for places where there's up to 199, over 200 people in attendance, but less than 799, the maximum fine is £10,000. But then in relation to enhanced duty premises, so these are the 800 or more, or if you're involved in a qualifying event, the sums involved are pretty staggering. So where you don't have an accounting period, or it's the organisation's first accounting period, or it hasn't ended, the maximum amount of fine that can be imposed by the SIA is £18 million. In any other case, so where you are then the accounting period exceptions don't apply. So it's an established event or an established premises, the maximum amount of the fine that the SIA can impose is £18 million or 5% of the person's qualifying worldwide revenue for the person's most recent complete accounting period. So it's whichever is the greater of the two, 5% of worldwide revenue or £18 million for a failure to comply with the obligations in this legislation. So, whereas for standard duty premises, the requirements are meant to be simple to comply with, and your exposure is around £10,000, if you fall into the category of being an enhanced duty premises or running a qualifying event, the potential consequences of not complying with the legislation are absolutely huge. So £18 million or 5% of the qualifying worldwide revenue. So if you're in that territory of being involved in an enhanced duty premises or a qualifying event, there is very much, in my view, a need to get some expert input into ensuring that you are complying with your obligations and not exposing yourself to the sorts of sums that I've set out. In addition to those penalties, there is the power to specify additional daily penalties. And the way in which the penalty is imposed, there's some guidance in the legislation, but it's meant to take into account the appropriateness of the penalty and ensure that the penalty is proportionate to the degree of the contravention. We haven't got any guidance as to what proportionate to which contraventions are going to be treated more seriously than others yet. But one hopes that when the SIA issues its guidance, we'll be able to see what are the sort of core expectations and and how it sets out how it's going to be treating what needs to be done to comply with these duties. There is the ability to appeal the penalty within 28 days to the tribunal. So it's not simply a case of there not being any redress mechanism, but clearly you do not want to be in the territory of facing a fine of this sort and then having to appeal after having had that imposed on you. So in addition to the penalties that the SIA can impose, we then have a whole series of offences that are created by the Act. And forgive me, I've just set out some of the information about the restriction notices there. Before we move on to offences, the restriction notices can include various things. I've set them out on the slide. And so they can prevent the event from taking place at all, or for the premises being used in the way that's proposed. Or they can place restrictions on the times or limit the numbers of people. So again, these are very powerful tools that the SIA have, both in relation to the financial penalty, but also in relation to the compliance and restriction notices, and have the potential to really compromise what's being proposed in terms of the usage of a premises or the way in which an event's going to be run. So I put out there the appeals in relation to notices which I've dealt with, and then we have offences. So what the Act does is, in addition to create powers by the regulator to issue penalties and then have an appeals process, you then have the ability to create criminal offences. And I've set out some of the offences there. So the failure to comply with a notice, a compliance notice or a restriction notice issued by the SIA, or the provision of false or misleading information. And as I've said, the offences can be they're summarily or can be tried summarily or on indictment, so in the Crown Court. And I've put the maximum amounts of imprisonment and fine available there. And the legislation makes express provision for there being a defence if you're able to show that all reasonable steps were taken to comply, which again goes back to the need to ensure that where there is where you have premises where there are large numbers of people present, or events where there are large numbers of people present, you need to consider whether or not expert advice is taken in relation to the security, in relation to the movement of people within those premises and the like, evacuation and evacuation, in order to ensure, and if you're able to show that advice has been taken and that you've complied with that, it seems to me that you're going to be managing the risk and you're managing your exposure then to a fine or to there being a criminal offence brought. There's also provision made with the legislation in section 26 for liability in relation to an offence committed by a body. And what it says there is that the irrelevant person also commits an offence if the offence was committed with their consent or connivance, or is attributable to their neglect. And relevant person here, so this is a definition that's separate to a responsible person. Relevant person in relation to this part of the legislation is set out and includes, in relation to a body corporate, an officer of that body or any other person concerned in the management or control of that body. Another example is in relation to a limited partnership, the general partner or any other person concerned in the management or control of the limited partnership. And in relation to an unincorporated association, for example, the person who is concerned in the management or control of the association. So there is personal liability created by the offence in relation to some of the organisations that might be involved in premises or in qualifying events. And so again, some serious consequences, particularly for some of you that are potentially social housing providers, say, and host events or have mixed use premises, and where the regulator, the ombudsman and the housing regulator are going to be taking an interest in whether or not there are criminal offences and compliance with the various regulations that bite on you as that type of body. So those are offences. I'm going to end with highlighting a few of the resources that are currently available. So as I've said, there are going to be some, or the SIA is required by the legislation to publish some guidance in relation to these provisions, and also their approach to investigation and enforcement of these obligations. In addition, there are some fact sheets available on the government's website. So there's a Martyn's Law fact sheet, and then there's another set of fact sheets, the first and second of those two links. And then the video that I mentioned earlier in relation to the cafe lockdown is also available on that link. It's a short video, as I say, but gives you an example of how fairly simple measures can be taken to ensure the safety of members of the public that are present in those premises, including things like where you have outside seating, bringing people inside, locking doors, asking people to move to an area out of sight or which is not accessible in the event that the premises were to be broken into. So they're simple measures, and what they're dependent on is ensuring that your frontline staff, your frontline officers, the people that are the waiters and waitresses in this example of the cafe are aware of what the processes and procedures are in the event that something like this were to happen. And really, this is what all of this legislation is designed to do, is designed to ensure that there is some thought given to what happens in the event of a terrorist attack. And it's not just about some of the things that hit up the headlines in terms of bombings and other types of things, but it could just be equally be something like knife crime or gangs and that sort of behavior, which you are then required to ensure that there is some thought given to how members of the public are protected in those instances. So it's about there being some thought given to it, and then there being some joined up thinking in relation to where there are premises within premises to ensure that there are measures in place to ensure people are protected and not at risk of being vulnerable to risk of harm from a terrorist incident. So I'd commend these resources to you. I'm also very happy to answer any questions that you have if you would like to email them to me. There are going to be some further resources made available over the course of the next 18 months or so. And when those resources are made available, I'll ensure that they are emailed to those of you who have signed up to view this webinar. If any of you were late joining the webinar has been recorded and will be made available, and you'll be able to either rewatch it or watch the bits that you missed. And as I say, if there are any questions or any follow-ups, please feel free to get in touch. Thank you all very much. I've just had a look at the Q&A and I'm going to take a few moments just to see if I can answer some of those questions. One of the questions that's been asked, that's an easy win, is are the slides going to be sent out? Yes, the slides and the recording are going to be sent out. So if there are any glitches or slides weren't moving on or you lost audio, you'll be able to rewatch and look at the slides in a bit more detail. And actually on the slides and in the notes section underneath the slides, there's some more information and paragraph numbers and references should you want to look at those in a bit more detail. In relation to licensed premises, at the moment, the way the legislation is drafted is it relates to applications for new premises licenses, and that's in the on the face of the legislation. They have obviously premises licenses get renewed from time to time, and so eventually they'll all get caught when you apply for your new premises license. But at the moment, it bites on new premises licenses. And one of the questions is, would an employer with over 200 staff in one central office count as a standard premises? Potentially you're in scope because of the 200, but what you need to look at is whether you're a Schedule 1 use. So it depends on what the Schedule 1 use, or rather what the use of the premises is, and whether that's a Schedule 1 use to determine whether or not you are in scope as far as the purposes of the scope of this legislation is concerned. And a similar question about workplaces where there are then events that are sometimes allowed to occur. Again, you have to look at whether those events are going to fall within the meaning of Schedule 1 use, and then look at the numbers to decide whether or not you become standard duty or enhanced duty or a qualifying event. But for premises purposes, it's about the use. For qualifying events, it's about the numbers involved and the control on access. And then the final one is in relation to childcare. Does that include schools? Yes, so it includes educational establishments such as schools. So childcare is covered in the context of both childminding or nurseries, and then also in the case of schools. Those are the questions on the Q&A. I'm just going to take another look to make sure that there aren't any other things I've missed. So there's one other thing that I think might be a more general application, and that's in relation to, I've already dealt with markets. So and I'm happy to answer follow-up questions by email if need be. There's a question here about a council-run venue which has a capacity of over 1,000 if at full capacity. But if a small event of 250 is taking place, does that mean that I'm still classed as enhanced? The answer is potentially yes. So it's that reference I made to, even if you're only sometimes going to be at that key number of 800. So in the run up to Christmas, when you're really busy in a shop, say, you are then classed as whichever of the two tiers apply. So you'll either be standard duty if it's 200 or more, or you'll be enhanced duty if it's 800 or more. So if sometimes at your venue you have 1,000 people and it's a qualifying use, it's a Schedule 1 use of those premises, then you are potentially in the enhanced duty category if it's over 800 people. There aren't any further timescales in relation to the implementation of this legislation, except that the Act has been passed, and so the expectation is that there will then be further information provided as to the nuts and bolts of the expectations. But the actual expectation in terms of the duties is already in the Act. It's just about how that's going to be fleshed out and how it's going to be investigated and enforced by the SIA that is going to be the subject of further guidance. And if you'd like some further information, as I say, when I see any more information being published, I will email it to you. But I also plan to do a follow-up webinar once we have a bit more information. But in the meantime, if you'd like any advice on whether or not you are in scope for the purposes of this legislation, do feel free to get in touch either with Dan or with me, and we can take it from there. The slides and recordings should be with you in the next couple of days, but in the absence of any other questions, I'm going to, actually the park run, that's a good one. Can I just deal with that quickly? Park runs are potentially included because of the numbers involved and because of the control on entry. But I'd need to take a closer look at that. I'm going to close the webinar now, but as I say, the slides will be available, and should you have any other questions, feel free to get in touch with either Dan or I. All the best.